Back in the studio, we're talking about Texas criminal law, crimes, consequences, and the court process. So, post-indictment, post-information, and post-arraignment hearing. Now, arraignment hearings can be handled through a waiver of arraignment where a defendant essentially skips that first hearing. I don't need to have my charge read to me in open court, Judge. I understand the allegation. I know what it is, and that's okay. So that waiver of arraignment is a step that is, you can skip the formal reading, enter a plea of not guilty, and then just begin negotiations with the state district attorney's office. So that's the plea process, right? And in that plea process, under our current state law, the district attorney's office has an obligation and a duty, as does defense counsel or the defendant if they're representing themselves, to put in writing that they want all materials that are subject to Texas Code of Procedure, Criminal Code of Procedure 39.14, also known as the Michael Morton Act, which means give me everything you got. In the universe of the allegations against me, I want to see it all. And the state district attorney's office has an obligation to turn that all over to you, and they need to do so with all due speed, and in my experience, they do. That allows the defense the opportunity to review and dig into the strengths and weaknesses of any case that the state may have put together against a particular defendant, and that the defendant would be in a situation where you're starting to evaluate levels of responsibility for things like the charged offense, any lesser included offenses, any other agreements that can be reached to take things off the table, to lessen the consequences so that the criminal defendant would be willing to reach an agreement with the state prosecutor's office on how to resolve the case. For example, if a defendant is a habitual offender simply because of the nature, they got 3 or 4 or 5 prior felony convictions, felony DWI, felony possession of small amounts of illicit drugs, right? Controlled substances, OxyContin, crack cocaine, methamphetamine, fentanyl, things that are clearly not we're not talking about people busted with pounds and kilos and scales and little dope bags. We're talking about people who are addicted, people who are coping with their own invisible injuries up here through drugs and alcohol. They have prior felony convictions. That means that, 3 strikes you're out, got to charge them as a habitual felony offender, makes a plea bargain very, very tough, right? But if you take that off the table, right? Take that off the table because this really isn't the most serious offense, and do we need to be clogging up the Texas prison system with essentially low-level, nonviolent offenders, drug offenders, at the cost of $60,000 a year? These are where the defense has some room to bargain, that maybe that the charged offense is just the habitual offender paragraph that's in the indictment, makes the consequences extremely hard, if not impossible to negotiate on. So if that could be removed, then the deal could be struck for something in that range of punishment that the defendant would accept responsibility. Or another frequently used avenue would be the lesser included offenses, right? So the state of Texas has alleged that this occurred, right, which is some sort of state jail, 3rd degree, 2nd degree felony, and there's a way to make the consequences more palatable to the defendant and not force the state of Texas to impanel 12 jurors, do all the work that's necessitated by a jury trial for something that can be resolved on a lesser included offense, right? For example, theft, breach of fiduciary duty. We're talking about essentially a white-collar offense. Most white-collar offenders are not violent offenders. They really need to be going to the penitentiary for 5 to 10 to 20 years. What would be a lesser included offense that could include some pretty harsh probated sentences or other things of that nature, stiff restitution, things that will keep people paying their taxes, supporting their family, not putting their family in jeopardy of also being on social welfare because the breadwinner's gone and in prison for doing something that, while not insignificant, is not violent, right? In other words, we're coming up with agreements to accept responsibility for criminal actions within that scope of lesser included offenses or other punishment alternatives so that we house the most violent offenders in our Texas prison system and we don't clog up the beds with essentially non-violent or low-level drug users, right? People who are struggling with mental disease and who are self-medicating with drugs and alcohol, or people who have not committed violent offenses. So these are the things that go into the plea bargain process. It can sometimes be a very fruitful, very beneficial, sometimes drawn out process, and sometimes it's a scenario that you do reach an impasse, right? All pleas are rejected, and we'll talk more about that in the next video series about what comes next when plea negotiations just fall short.